Welcome back, and thank you very much for staying with us right here on KTN. And we have been bringing you updates on the news desk, but at this point in time, we seek to answer the questions of what next. What did it actually mean, what the three-judge bench said and declared in as far as their recusal petition is concerned? I am not the expert here, but I have an expert in studio. He is a lawyer. And of course, I want to appreciate John Swaka for being with us all the way from, I believe, the morning session with the Kiswahili team. And now we need to hear it, Wakili, in English. Good afternoon.
Good afternoon.
We watched this with you.
Yes.
We followed this closely with you as well. The petitioners that came forth to, ask or pray that the court would consider the recusal of the three-judge bench, the principal judge being Eric Ogola, and we also have Justices Freda Mugambi and Anthony Murima. Now, in that regard, there has been a concern and the big question, on what basis we are having this recusal, a request? Is it a matter of law? Is it a matter of principle and perspective?
Thank you so much. You realize what the judges have done. Basically, they have given a very brief
very
finding.
brief.
Yeah,
yes.
They just went straight to their finding. They've said a detailed report or a detailed decision will come out, and they'll show their points of determination.
And so far, also, just to make it clear, this three-judge bench has, I don't want to use the word refused, but if it is correct, refused to recuse themselves.
Definitely, that's the right word.
All right.
They basically refused, or rather, they have rejected or dismissed the application for their recusal. So what that then means is that they are now the bench that will continue. The started hearing will continue and will determine this matter to the end. Of course, the court has given them, the litigants, a leave to appeal should anyone feel dissatisfied with that decision.
All right.
Any one of them can proceed to the Court of Appeal and challenge that particular decision.
So they can challenge the fact that the judges remain, the three-judge bench that will proceed with the hearing.
Yes.
So there is a window for the petitioners to proceed and appeal.
Yes.
If they do, and the courts of appeal then, are of contrary opinion to what Justice Eric Ogola has given as their position, what happens?
Of course, if the Court of Appeal will hear, of course, the first thing they might attempt to do is to get a stay, so that this particular bench does not continue hearing the matter. So it means you file your appeal, the Court of Appeal then stays this decision. And that means that principally this bench is stopped from further listening until this Court of Appeal determines that particular aspect of the appeal. And of course, if it determines that the litigants are wrong, go back, can dismiss the appeal, it means they go back to the same bench. But if they find merit in what they're saying, then of course the direction will be for the CJ to then appoint a different bench.
Now here's the confusion for a layperson, is we have a window for appeal to challenge the three-judge bench, which is then expected to continue with the hearing of the Deputy President impeachment trial. And they've even given a hearing for 29th of, another session for 29th October 2024 at 10 a.m. That is pretty much just next week. And now the question is, as the other petitioners might decide to appeal, yet we are still awaiting them to proceed with this same judge, three-judge bench. How does that work out?
It happens every day. You are allowed to appeal as the matter proceeds. What basically will make this current matter before the three-judge bench not to move on is not the mere fact that somebody has appealed, but it is that the Court of Appeal has then stayed or stopped this particular bench from moving on with the matter until the appeal has been heard and determined.
At that point, are we given another bench?
Yeah, that's what I'm saying.
Okay,
in the interim, unless the court stays or stops this particular bench from further listening to the matter, this bench will listen to the matter, and it's actually given a date for 29th.
All right.
But should somebody appeal, and of course, should an application for stay be filed, considered, and of course, issued by the Court of Appeal before the 29th, then that means that then this court does not proceed on the 29th because will have been the decision the decision to have it proceed has been stayed.
All right.
So that's a likely scenario. But should they just appeal, file maybe for a stay, but the stay is not granted, The 29th, this court is well seized of the matters, and it will proceed to hear them as directed.
I appreciate that you gave us a timeline, because that was something very, important for you to say, that it is important for them to appeal before the 29th of October, at least 10 a.m. But let me also bring in now another, need for clarification. What I asked you earlier on, is it based on matters of principle, based on matters of, perspective, if not law? Because what you have seen here is the petitioners are bringing in concerns around the relationships, with the judges. In certain times, we're seeing, Murima here is being accused of not being accused. The concern is that there's closeness, friendship with the senator with the speaker, Senate of the Senate, that is Amason Kingi. We're seeing a spousal. Our spouse being, brought in on this matter as an appointee of the president, which then brings out the question if they are impartial or if they will be biased to the executive. Remember, John Ahaminwa actually, pardon me, yesterday, vividly and outspokenly told the judges, owing to his experience, that if anyone feels uncomfortable with them, the best thing and the most prudent thing for them to do should have been to step out of the bench.
Recusal is not done that way, not just because somebody has raised an issue touching on relations or other principles. It must go to the root of the impartiality of that particular judicial officer. And of course, as you heard from the principal judge, Justice Ogola,
yes,
a detailed ruling will come out. They have considered all these parameters, they have considered all these tenets that were raised. They must have, of course, in their ruling, they must have risen up to the occasion and rebutted all of them for them to come up with a decision that we are not recusing ourselves. But be as it may, any party has a right to tell a judge, a magistrate, a judicial officer, I don't feel comfortable owing to this reason or to that reason, I feel you'll be impartial and all that. But that does not mean that it must be translated into an order for recusal. A recusal should be exercised in a very wise manner, in a manner that does not then allow litigants to go for forum shopping. Because if I don't want to be before you, I'll just raise up issues and say, recuse yourself and let somebody else come. That then will make justice look like you can shop for it. You can decide which judge, which judicial officer will hear what, will decide what, will hear me, and all those kind of things. So the judiciary is enjoined to actually not encourage those applications for recusals just at a very whimsical level. It must have roots. It must be weighty. It must demonstrate to all and sundry that if we were to proceed in this manner, then a miscarriage of justice will occur.
But anyway, let's bring it in. What you're saying in a nutshell, if I get you correctly, is that justice is not bent to your convenience.
That's right.
But either way, what the question is, will the particular petitioners or those who are supporting and are following the impeachment motion be satisfied with the findings or the final verdict of this three-judge bench based on this foundation that we're really seeing in the end time?
It's up to any litigant who is dissatisfied to appeal. That is why we have all those mechanisms. The court will play its role as an arbiter and make its decision. The decision may not be pleasing to everyone, but whoever is dissatisfied always has a mechanism of appealing to a higher court, which can, if there is merit in the appeal, can interfere with that decision.
Because so far we even had some senior counsel saying their concerns are not anything to look at to be in terms of that these particular justices have been found with any personal maybe accusation or allegation for not being fit to be in the bench. There were concerns about them sitting and how they were actually, appointed to be at the bench. All these things, according to Judge Ogola, will be detailed. But the question is, how do they then reach this particular, verdict that they are not going to recuse themselves? The person would ask, or anyone would ask, what happens behind the scenes? Do they consult with the CJ? Do they go back to the DCJ? How do judges, or is it amongst themselves, in their own understanding, come up and say, based on this 1, 2, 3 things, we're not recusing ourselves?
Of course, there's no consultation with the CJ. Every judge is independent. When you talk about the independence of the judiciary, it's not only that the arm in itself is independent, but the judges, the peculiar judges or magistrates are not.
All right.
What it entails is that even when it comes to the judges themselves, they're independent in their work to the extent that no other judge can influence another judge. The CJ cannot influence any other judge. Neither can the judges influence the CJ in any way. Every judge is independent. So this decision does not take them to consult with anybody else.
All right.
Maybe to consult with the law, to look at the issues raised vis-a-vis what is before it, to look at the law, and then they come up with a decision. So each one independently has come up with his own decision that I'm not recusing. So the bench says, we won't recuse ourselves. We are ready to proceed and be heard on this.
That is very, very detailed. Thank you very much for the quick summary interpretation of what we have seen today at the corridors of justice, Wakili John Swaka.
And the most important thing you have to remember is that they have allowed all parties to exchange all documents so that come on the 29th.
Yes.
Remember, each one of them is filing some short submissions.
Yes.
So that on the 29th, each party is given ample time to expound on their cases, and then perhaps a ruling is delivered.
And we remember yesterday, Justice Eric Ogola made it clear, said, and he gave this warning to all the petitioners not to take the court in circles. And so far, of course, just as you have said, I will echo, he has said that each of those parties should file their responses and serve one another. So then we're looking forward to some proper flow in the corridors of justice moving forward.
Yes, definitely. The petitioners will start their case.
Yes.
Then the respondents will. The petitioners will have an opportunity for a rejoinder. Then the court will retire to make a decision.
All right.
Yes.
Thank you very much. I hope we'll catch up with you again next week.
Thank you so much.
All right. That is John Swaka, who is a lawyer, just letting us know deeper in detail what legally the courts have agreed to in as far as recusal is concerned. And it is now loud and clear that the 3-judge bench shall proceed on the 29th of October 2024 at 10 a.m. And of course, they've left a window for anybody or any petitioner to appeal on this recusal agenda or matter. Stay with us at KTN News on X and on social media for more. Now let's cross over to other important developments this afternoon, and the 3rd Mukulima Expo